The Honorable, the Supreme Court.
Good morning, everybody. Thank you. Please be seated. And please call the case.
Good morning, Your Honors. The matter before the court this morning is entitled State of Vermont versus Jessica Morrill, case number 24 AP 137. Representing the appellant, the State of Vermont, is Attorney Evan Meenan. Representing the appellee, Jessica Morrill, is Attorney Jill Martin. Seated at council table with Jill Martin is Katie Holcroft.
Thank you. Thanks very much. Good morning, everybody. We'll hear from counsel for the appellant. Please come on up. Attorney Meenan, you know the way, I think. Yeah,
I would hope so by now.
I think so. Yeah. Okay. Please, just for the record, if you would identify yourself and your client and then proceed.
Yes. Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking this court to conclude that the civil division, not the criminal division, has jurisdiction to hear motions filed pursuant to 13 VSA section 2658. This appeal does not require this court to conclude whether or not the appellee was a victim of human trafficking or whether or not her assault and robbery conviction was the result of her being a victim of human trafficking.
So those findings have been made, Mr. Meenan? Specific findings that she was a victim?
Yes, those specific findings were made by the division in Washington County, but it's the state's position that that court did not have jurisdiction to make those determinations. And as a result, a new hearing is required in the civil division where the parties can either continue to disagree as to those points or potentially reach some type of resolution.
So why isn't your position just a second bite at the apple for you?
Because it would be, because jurisdiction is a threshold determination that any court has to make before issue a ruling. So yes, if this court were to agree with the state's position in this case, then yes, it would be a brand new hearing and the state would have a second chance to contest any of the appellee's facts or evidence. That would be the nature of the posture of the case upon any remand.
Mr. Meenan, one thing I'm really struggling with is the Constitution requires the legislature to determine the site of jurisdiction for cases. And so how can we be in the business of making that decision for them when they fail to do it here?
Well, the state in this particular case is not asking this court to step in where the legislature has failed to do so. What the state is asking in this case is for this court to apply the statutes that the legislature has enacted that establish court's jurisdiction. And it's the state's position that those statutes dictate that the civil division has jurisdiction.
Well, it's not clear. You'll agree that it's ambiguous and that we would have to look at the statutes themselves to determine intent, which is what we would do in any other case. But because they didn't specifically name the civil division or the criminal division, how is it up to us to make that decision?
I don't think that this is necessarily a case of ambiguity. And the reason for that is that there's two reasons for that. And those are the same two reasons why the state is asserting that the civil division is the correct court to adjudicate these motions. The second reason, which the state focused a small portion of its brief on, directly answers your question. And that is, let's just assume this court were to decide that because section 2658 uses the word the court, there is a little bit of uncertainty, right? Then the state's position would be, let's go back to Title IV and take a look at what the legislature has done in this state's jurisdictional statutes. And what the legislature has said in, I think it's 4 VSA section 31 subsection 5, is that the civil division shall have jurisdiction to hear and dispose of any other matter brought before the court pursuant to law that is not subject to the jurisdiction of any other division. So, for example, in the PCR statutes, where it's been fairly uncontested for as long as I'm aware that the civil division has jurisdiction, And unlike in your normal Chapter 230 expungement petitions, where it's pretty clear it's the criminal division, Section 2658 just uses the words "the court." So it's the state's position that you could go back to Title IV and say, even if we're not going to treat this like either a PCR or an expungement, in other words, it's its own creature entirely, it would still be the civil division that would adjudicate these motions.
So let me direct your attention, if I might, to 2652,
Okay.
which provides for an affirmative defense on
Yes,
the
Your
human
Honor.
trafficking. That would necessarily have to be heard in the criminal division. Huh?
That would be heard in the criminal division in any trial in which the person was being prosecuted for one of the offenses to which that affirmative defense applies.
So you don't think that that has any bearing on how we consider 2658?
I'm not saying that it has no bearing, but I think that you also have to weigh that particular consideration against some other considerations that the state thinks are equally valid. For example, where this court has said that you can't assert claims that would be traditionally advanced in a petition for post-conviction relief in criminal division matters, it has pointed to a number of policy considerations to support that. For example, all of the procedural benefits that come with PCR petitions, such as whether or not there should be any discovery involved. That's addressed in PCR, in the PCR statutes. It's not addressed in this statute. And that has particular import here, where the April 22nd, 2024 transcript on pages 92 to 93 make it clear that the appellee in this case did not want the state to engage in discovery and took the position that the state was not even entitled to know the identity of her alleged trafficker so that the state could investigate those claims. If, as the state asserts in its brief, Section 2658 statutes are treated like PCRs, that question would be answered. So too would be, for example, whether or not decisions on those motions are appealable, which was another issue that we encountered in this particular case, whether or not the movement is entitled to counsel at the state expense, and whether or not the judge who presided over the criminal case can even consider the motion.
Mr. Meehan,
Isn't,
can we, go ahead, Chief.
oh, okay, thanks. Isn't the underlying gravamen of a PCR very different than what we're looking at here? The Covios case talks about a defect in the conviction that the procedure for a post-conviction relief seeks to correct. And there are other cases that talk about problems with the colloquy that the court has undertaken, for instance. Doesn't that augur in favor of what the trial court did here?
Well, of course, the state would not dismiss offhand the language that this court has used in prior cases when applying or interpreting the PCR statutes. However, I think what this court should do is turn primarily to the language of the PCR statutes themselves before turning to the case law in which this court hasn't interpreted those statutes. So while, yes, the typical PCR in the state of Vermont might relate to something like an ineffective assistance of counsel claim, and therefore the language which Your Honor just cited is particularly relevant, the language of the PCR statute itself is slightly different. And that the phrases and the words used, for example, in Section 7131 are really important. It talks about, quote, vacating or to vacate, quote, the judgment or the conviction. And it says, for any reason, because it is otherwise subject to collateral attack, including, for example, because the Constitution violates the laws of the state of Vermont. So what the legislature has done with Section 2658 in the state's position is it said, we're extending this affirmative defense, with Justice Eaton just discussed, to human trafficking victims. But as part of doing that, we are also going to enable them to assert that after the fact to collaterally challenge their conviction, because if they had successfully asserted that affirmative defense in the first instance, their conviction would not have been able to be imposed consistent with the laws of the state of Vermont.
But
I'm sorry, if someone wanted to do that, you confirm that someone can do it after the fact rather than use the defense. Under our PCR case law, you have to be in custody under sentence, right? To bring a PCR case. And so wouldn't that then prohibit certain individuals who would be entitled to make this claim from doing so unless they were in custody under sentence?
That would impose some temporal limits. I mean, as the court is aware, there's some exceptions to being in custody and under sentence, or that concept has been expanded somewhat, for example, when you're challenging things like enhanced sentences. So there is some wiggle room. But yes, that requirement that's imposed in PCRs would, for example, prevent someone from challenging conviction under 2658 50 years after the conviction was imposed, or some extended period of time after it was imposed. However, that needs to be balanced against the other considerations which I mentioned, which are, for example, Section 2658 motions. PCRs would permit things like discovery, which could benefit both a defendant and the state.
But doesn't PCRs, Mr. Meaning, go to how the case was litigated rather than challenging the underlying facts of the charge? Like, for example, in this case, was the appellee the victim of human trafficking?
In the typical PCR that's brought in the state of Vermont, yes, that is usually what happens. Like Justice Reiber, accurately identified. Are we talking about an ineffective assistance of counsel claim? Are we talking about a Rule 11 colloquy? However, as I mentioned, I would encourage the court to go back to Section 7131 because the language makes clear that a PCR can be brought essentially for any purpose that would constitute a collateral attack upon either a sentence or a judgment.
But if
the-
PCR,
Go ahead.
can the PCR court expunge a conviction?
No, the remedy in a PCR is to vacate a conviction, which is one of the similarities between a Section 2658 motion and a PCR. The remedy in a 2658 motion is to vacate the conviction. Now, there is the additional benefit of having a conviction expunged. However, as the state pointed out in its brief, expungement in the context of a 2658 motion is different from expungement in the context of a Chapter 230 motion. 2658 makes clear that what expungement really means is to redact the name of the successful movement from all of the underlying paperwork. Whereas in Chapter 230, it's very clear that expunge means destroy. So the remedy is not the same. However, what is the same between a PCR and a 2658 motion is how it's initiated. It's a motion. Even though we normally refer to PCR petitions, the statute actually calls them motions. The standard is the same. It's a preponderance of the evidence. And then, as I just mentioned, the remedy is the same as well, which is to vacate a conviction.
As an aside, what's the standard on the affirmative defense?
Oh, that's reaching back. I believe how it works in an affirmative defense, the state might have an obligation to disprove it if the defendant makes a sufficient showing that they're entitled to assert the defense before a jury. I think I'm getting that right. I think that's how pretty much all affirmative defenses work. But I think that the standard for asserting the affirmative defense in the first instance would be different from successfully moving pursuant to Section 2658.
How have other states treated this?
Well, I think that the appellee has urged as one of the reasons why this court should treat them like expungements, or at least allow the criminal division to assert jurisdiction, is that most states that have adopted this type of legislation have permitted their criminal courts to handle them. However, Vermont is its own jurisdiction. It gets to decide things. The Vermont legislature gets to decide how jurisdiction is apportioned between our courts. And just because other states do things one way does not mean that Vermont has to follow. For example, many states have things like intermediate appellate courts. It doesn't mean that litigants in Vermont get 2 appeals. We can decide to limit them to 1. And I'd like to reserve the rest of my time
Okay.
if possible. Thank you.
Thanks very much. Attorney Martin, if you would want to please, and for the record, if you would introduce yourself, identify your client, and then proceed.
Sure. Good morning. May it please the court. My name is Jill Martin. I'm an attorney with the Prisoners' Rights Office, and I've had the pleasure of representing the appellee in this matter, JM, for several years. With me at council table is my law clerk, Katie Holcroft, who appeared with me in proceedings below. Though she won't be arguing today, she will be hopefully joining the bar in Vermont in the fall.
Well, welcome. Nice to have you here.
So it is our strong belief this morning, the trial court below correctly concluded that the criminal court has jurisdiction over motions brought pursuant to 13 VSA 2658. We do not dispute that section 2651 does not define the word court for the purposes of chapter 60. However, this court needs to read section 2658 taking into consideration its enacting legislation, its subject matter, its effects, and most importantly, the spirit of the law. Section 2658 was amended to its present form as part of a larger legislative effort in 2019. The act that amended it was literally captioned an act relating to sealing and expungement of criminal records. This legislation dramatically broadened the scope and number of offenses eligible for expungement and sealing. It also contains specific language relating to human trafficking, both the amendment of section 2658, as well as a directive to the Attorney General's Office, the Center for Crime Victim Services, directing them to examine Vermont's existing framework as it pertains to human trafficking, to modernize it, and to ensure that Vermont keeps pace with best practices in other jurisdictions.
So it's an affirmative defense that can be raised at the trial and then be a decision for the jury to make whether or not the defense would be available. If it's not raised in the jury trial, and would it be a potential PCR ineffective assistance of counsel in a later proceeding, or are they mutually exclusive?
I don't believe they're mutually exclusive. I think potentially it could be an ineffectiveness claim. However, to the best of my knowledge, no one has ever used this affirmative defense. In fact, I think, as the state correctly pointed out, I was not even aware of its existence, despite the fact that I've been litigating these motions for several years. And I think that has a lot to do with the experience of human trafficking survivors in Vermont. What we have seen and what the legislature has inherently recognized is that trafficking survivors are in understandable fear of their traffickers. They have endured unimaginable trauma. And to stand up in court, to name their trafficker, to face them down, to describe in public and in great detail all of the horrors that they have endured might be too much for some litigants.
So, Ms. Martin, if we would agree with the state that this should have been brought as a PCR, the trial court here made very specific findings on the record regarding the events that led to your clients doing the bank robbery. What happens to those facts?
Well, I think like any other case, it is expunged, and under 7606 of Title 13, those are sealed. And hopefully my client gets to move on with her life.
Does it make any sense that in one context, if this is raised as an affirmative defense, it's in the criminal division, but if you elect to wait and file it after conviction, then it would be in the civil division? I don't understand why there's a difference here, or why there should be a difference.
Well, I think, Your Honor, with all due respect, that the PCR statute contains an explicit jurisdictional bar that an individual needs to be in custody and under sentence.
I'm not talking about a PCR
Okay.
under 7131. What I'm talking about is bringing it under this statute, under 2658. Does it make any sense that a 2652 issue is in the criminal division clearly because it's an affirmative defense, but then the state says, oh, you need to go into the civil division if you wait and file a claim for relief under 2658. Why does that make any sense?
I think logistically it would be incredibly difficult. I think petitions for expungement are brought in the criminal division. That is abundantly clear. They are captioned motions, and that is identical to this case, where This is something that is well within the purview of the criminal court. I think to bring it into the civil court would cause issues as to, number one, whether the court could even hear it, but also what relief the court could grant. Section 2658, yes, does allow or does direct the court that hears the motion to vacate the conviction, which courts regularly do as a part of PCRs, but it also orders the court to expunge. And I don't believe the civil court has that inherent power. That is the power that is that lies with the criminal division.
So with that analysis, there'd be no ambiguity as to what the court in the statute in 2658 says. If the only court that can expunge is the criminal division, then isn't that the answer?
I believe so. I think the language in 2658 is very, very clear. And I also think that the legislature wisely drafted 2658 to its present form as a part of the expungement statutes for a reason. The legislation itself speaks to wanting to give people who picked up convictions due to external circumstances, whether it be the defendant's age, whether it be the amount of time that has lapsed between the offense and the petition for expungement, or whether they were a trafficking victim at that time, merits the relief.
So, Ms. Morrill, I'm sorry for interrupting you, but that brings up a point. I mean, then, can the affirmative defense be litigated in civil?
I don't believe so.
Why?
Because I don't think that it was intended to do that. I think to allow the affirmative defense to be litigated in civil court would dramatically expand the use and function of a PCR without legislative approval to do so. I think it's a slippery slope. What is to stop the PCR court from then hearing other kinds of affirmative defenses? This court has held and has found that those are properly raised as ineffectiveness petitions as a part of a PCR, but whether a PCR court can in fact conclude
that JM was a victim of human trafficking is a very different different finding. Thank you.
I think this court also should examine practices both inside the state as well as outside of the state to inform its decision in this matter. Due to the nature of relief afforded, expungement and vacator records are somewhat hard to come by. However, as I indicated earlier, I've had the privilege of litigating the vast majority of these cases. Criminal courts throughout the state have correctly concluded that jurisdiction lies with the criminal division.
Any courts decide the other way? Yeah, there's 5 courts that.
There's one court that I'm aware of. I believe the state pointed to that decision where a pro se litigant filed a motion under 2658 and the criminal court concluded it did not have jurisdiction. To the best of my knowledge, she did not have counsel.
I'm going to echo what I asked Attorney Meenan. You're making a lot of policy arguments. And again, I'm concerned that it's the legislature who should be making those policy considerations and choosing the site of jurisdiction, the correct forum. Why should we do that? How can we and why should we?
Because I think the legislature did correctly conclude that the criminal court had jurisdiction, though perhaps they didn't include a strict definitional element in section 2651. Act 230, which again amended section 2658 to its present form, contains specific language in sections 10 and 11 relating to expansion of the laws on human trafficking to encompass best practices around the state, and also speaks to the general purposes of expungement. I think the legislature, though again, perhaps inartfully failing to include a specific definition, made it abundantly clear that expungement petitions are important to litigants who need to move forward with their lives and that human trafficking victims fall into that class of litigants.
What would happen if we agreed with you that this should be jurisdiction in the criminal division? What would happen to that one case in Vermont where the judge determined it should be in the civil division and it was?
I think that we would likely reach out to that individual, offer our services if they so agreed, and work on that case with them. I think that decision is standalone. And upon review of the decision, it was not fully briefed. The decision is quite short. In contrast, there's a very lengthy decision at printed case page 46 from Judge McDonald Cady in Bennington as to why the criminal division in fact has jurisdiction, as well as a very well-reasoned decision from Judge Morrissey on the record in Lamoille County.
What weight should we give to the fact that in two places, by my count, in this statutory scheme, the statutes on human trafficking do call out the civil division, specifically in 2656 and 2662, but it is not called out in 2658.
So I think those sections deal with very specific subject matters. 2656 deals with human trafficking by business entity, which again generally falls within the purview of the civil division. And the section of 2652 that I believe you're referring to also refers to some remuneration for experiences endured by human trafficking survivors. So I don't think that these are antithetical positions to one another.
No, but my point is, in two locations, the court is specified as the civil division. And elsewhere, it simply says the court, or doesn't say anything. Doesn't that, if the legislature has said the civil division in two places, but not elsewhere, doesn't it mean that they didn't mean the civil division there?
Yes, yes, it does. Along with everything else, yes, it does. And I just wanted to raise one additional point, if I could, which is, I see my light is flashing, that the PCR statute does contain a very important jurisdictional bar, which requires the movement to be in custody and under sentence. Were this court to find in favor of the appellant, that would grossly limit the availability of survivors of human trafficking to seek relief. It would require that they be under sentence. And that is not what the legislature intended. And that is also quite contrary to the experience of trafficking survivors. What the transcript below revealed is that my client did not acknowledge her trauma nor identify her experience as human trafficking until years after it had occurred. It took many years of incarceration and understanding trafficking to even begin to say, wow, I am a victim. And so were the court to find that this—
Before your light's not on yet, so I can ask you one more question. So,
Of course.
the fact is, it can be raised as an affirmative defense. And then and if it's not raised as an affirmative defense, it can be raised afterwards. There's no waiver there. Are you aware of any other statute that has that requirement? That if you don't make it as a defense and during the trial, it's gone?
I am not aware of any similar statute. I do believe that the language in 2652C2, which provides the affirmative defense, and 2658 are distinct in several ways. So 2652 requires a person to prove, that the criminal conduct arose out of the sex trafficking, whereas 2658 requires that the person was convicted of an offense as a result of them being a victim of human trafficking. And though the state in its reply brief, I think saw those as one and the same, they are in fact quite different. And the legislature wisely chose those words differently. So I think though someone may be able to prove an affirmative defense, in fact, the causation under 2658 is a bit more relaxed. It's different. And that avenue should remain open to trafficking survivors in criminal court. And with that, I thank you all for your time.
All right, thank you very much. Does the appellant have time, please?
Appellant has 1 minute and 30 seconds remaining.
Counsel?
Boy, okay, I'm going to try and cover a few things very quickly, if I may. I wanted to start off by addressing a question that Justice Eaton rose about whether it makes sense to have the criminal division consider this in the context of an affirmative defense, with the civil division considering it in the context of a post-conviction motion. And I would just remind the court that it's the nature of the case and the type of relief sought that dictates jurisdiction. And it is not true that the criminal division is the only court or entity in the state of Vermont that has the ability to rule on whether or not a record should be sealed or expunged. The family division specifically has that jurisdiction pursuant to sections 5119 and Title 33. In addition, DCF has that authority with respect to child abuse registry entries, and the Department of Disabilities, Aging, and Independent Living can do it in response to the Registry for Abused Adults. So there are other entities in the state of Vermont, aside from the criminal division, that make these types of determinations. Assigning 2658 motions to the criminal division solely because it has some relevant experience in another context would be consistency for consistency's sake. I would also like to point out, I believe that this is correct in the record because I went back and checked the trial court docket, and there was some post 2658 litigation in this case about reimposing the defendant's or the appellee's sentence. So my understanding from that litigation was that the appellee would have been able to file a PCR in this particular case to assert the same claims that she asserted in her 2658 motion. Thank you very much.
Okay, thank you. Thank you both. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for